Ohio has a well-established lease termination framework that balances landlord and tenant rights with a clear set of procedures. The governing law is found in the Ohio Landlord-Tenant Act, Ohio Revised Code Chapter 5321, along with the state's forcible entry and detainer provisions in Chapter 1923. If you manage rental property in Ohio, following these procedures precisely is essential because Ohio courts are strict about compliance. Let's start with no-cause termination. For month-to-month tenancies, Ohio requires either party to provide at least 30 days written notice before the termination date. The notice must be delivered at least 30 days before the periodic rental date, meaning the date rent is due. So if rent is due on the first of the month and you want the tenancy to end on the last day of March, you need to deliver notice by March 1st at the latest. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required. Ohio does not require the landlord to provide advance notice that a fixed-term lease is ending unless the lease itself requires it. If the tenant remains in possession after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement on the same terms. For week-to-week tenancies, Ohio requires 7 days' notice from either party. Now let's cover termination for cause. For non-payment of rent, Ohio's process is unique compared to many other states. Under Ohio law, the landlord must provide a 3-day notice to leave the premises before filing for eviction. This is a 3-day notice to vacate, not a 3-day notice to pay or vacate. The distinction is important. Ohio's notice does not give the tenant the right to pay the rent owed and stay. Once the 3-day notice is delivered, the tenant has 3 days to leave, and if they don't, the landlord can file a forcible entry and detainer action. This makes Ohio one of the stricter states for non-payment. The tenant technically has no statutory right to cure the default during the 3-day notice period. However, in practice, if a tenant shows up at the hearing and pays the full amount owed including court costs, many Ohio courts will allow the tenant to remain. But this is a matter of judicial discretion, not a statutory right. Landlords should be aware that outcomes can vary by judge and by court. For lease violations other than non-payment, Ohio uses a 30-day notice to cure or vacate framework. Under Section 5321.11, the landlord must provide written notice specifying the violation and informing the tenant that if the violation is not remedied within 30 days, the rental agreement will terminate. If the tenant cures the violation within 30 days, the notice is void. If the tenant doesn't cure, the landlord can proceed with filing for eviction. 30 days is a longer cure period than many states provide for lease violations, which means Ohio tenants have more time to address the problem before losing their housing. Landlords need to plan for this timeline and be prepared to wait out the full 30 days before taking the next step. For repeated violations of the same type, Ohio allows the landlord to issue a subsequent notice and proceed more quickly. If the same violation occurs within 6 months of a prior notice, the landlord can give the tenant a reasonable time to correct the issue. But if the tenant has already been through the notice process for the same violation, the court may be more willing to grant the eviction on the second occurrence. For serious violations, including criminal activity, drug offenses, and conduct that poses an immediate threat to health or safety, Ohio provides a more expedited pathway. The landlord can issue a 3-day notice to vacate without providing an opportunity to cure. This applies specifically to situations involving illegal drug activity on the premises and to situations where the tenant's conduct creates an imminent risk to other residents or to the property. Ohio also has specific provisions addressing the termination of public housing and subsidized housing tenancies. For Section 8 and other federally assisted housing, additional notice requirements and procedural protections apply on top of the state law framework. Landlords who participate in housing assistance programs need to comply with both the state procedures and the federal program requirements. One area where Ohio has gotten increasingly detailed is the notice delivery requirements. Ohio law requires that notices be served by one of several specified methods: personal delivery, leaving a copy at the tenant's usual place of residence with a person of suitable age, or sending the notice by certified mail. Improper service can result in the notice being invalidated and the eviction case being dismissed. Ohio courts take service requirements seriously, so documenting how and when the notice was delivered is critical. The eviction process in Ohio goes through municipal court or county court, depending on the jurisdiction. The landlord files a complaint for forcible entry and detainer, and the court issues a summons to the tenant. The first hearing is typically scheduled within 2 to 3 weeks of filing. Ohio requires the landlord to attend the hearing. Failure to appear results in dismissal. If the court rules in the landlord's favor, a judgment for restitution is entered. The tenant then has a period, typically a few days, to vacate before the landlord can request a writ of execution. The bailiff or sheriff then carries out the physical eviction. The overall timeline from filing to removal is typically 4 to 6 weeks for uncontested cases, but can be longer if the tenant raises defenses or the court has a heavy caseload. Ohio tenants can raise several defenses in eviction proceedings. The most common defenses include improper notice, the landlord's failure to maintain habitable conditions under Section 5321.04, retaliatory eviction, and discriminatory eviction. If the tenant can demonstrate that the property has unresolved habitability defects that the landlord knew about, the court may deny the eviction or reduce the amount of rent owed. This makes habitability compliance directly relevant to the landlord's ability to successfully pursue an eviction. On the tenant side, Ohio provides several grounds for early termination. If the landlord fails to maintain the property, as we covered in our Ohio habitability video, the tenant can provide written notice and allow the landlord a reasonable time to make repairs. If the landlord doesn't act within 30 days for non-emergency issues, the tenant can pursue remedies, including lease termination. Active duty military members are covered by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Ohio provides early termination rights for tenants who are victims of domestic violence. Under Section 5321.17, a tenant who is a victim of domestic violence, dating violence, sexual assault, or stalking can terminate the lease by providing written notice along with a copy of a valid protection order, a police report, or other qualifying documentation. The tenant must provide at least 30 days' notice, and the landlord cannot charge early termination fees. The tenant is responsible for rent through the termination date and for their share of any damages to the property, but is not liable for future rent. Ohio also provides early termination rights for tenants who are 62 years of age or older and need to enter a care facility. The tenant must provide at least 30 days' notice along with documentation of the need for care. Ohio strictly prohibits self-help evictions. Under Section 5321.15, landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out. The penalties are significant. The tenant can recover actual damages, reasonable attorney's fees, and a civil penalty. Ohio courts consistently enforce this prohibition, and landlords who attempt self-help not only face financial liability, but also risk having their eviction case dismissed if the court finds they engaged in improper conduct. One practical consideration for Ohio landlords: the state's larger cities each have their own local requirements that can affect the termination process. Columbus, Cleveland, Cincinnati, Akron, and Toledo all have local housing codes and court procedures that may add steps or requirements beyond what state law mandates. Cleveland, in particular, has been active in expanding tenant protections, and landlords in that city should be aware of local ordinances that may affect how they handle lease terminations. Ohio requires landlords to return the security deposit within 30 days of the tenant vacating and providing a forwarding address. The landlord must provide an itemized statement of any deductions. If the landlord fails to return the deposit or provide the statement within 30 days, they may be liable for double the amount wrongfully withheld plus attorney's fees. If the tenant doesn't provide a forwarding address, the landlord must mail the deposit to the tenant's last known address. For the complete guide to Ohio lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.